Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. Okay, Professor Theodore Christakis is with us today. He is Chair of AI Regulation at the University of Grenoble, Alpes, Professor of International and European Law at the same university, Director of the Center for International Security and European Law, Director of Research for Europe with the Cross-Border Data Forum, Senior Fellow with the Future of Privacy Forum, and a former Distinguished Visiting Fellow at the New York University Cybersecurity Center. He has been a member of the French National Digital Council and he is currently serving as a member of the French National Committee on Digital Ethics, as well as a member of the International Data Transfers Experts Council of the UK government. As an international expert, he has advised governments, international organizations and private companies on issues concerning international European law, cybersecurity, AI and data protection law. He has been involved in international negotiations and has served as an independent expert for numerous law firms. And just to cap it all, in case it wasn't enough, he also has real-world experience as a DPO. Of course, we're going to talk about the overlap between GDPR and the AI Act, hallucinations, and how to handle different risks in LLMs and their output. Let's go for it. Theodore, thank you for joining me.
It's a pleasure to be here, Sergio. Thanks for the invite.
Great, fantastic to have you. Okay, let's start with something that I don't know how light it is as a start, but maybe it's a good start. So let's approach one of your papers, right, and talk about the EDPB Opinion, right, on LLMs and personal data. And a good approach to that could be talking about the good, the bad, and the ugly. As in your LinkedIn post, referring to again your analysis of the paper.
Yes, thanks, Sergio. The idea is not to suggest that the GDPR is turning like a Wild West AI shootout. It's not quite the OK Corral. But the GDPR can indeed feel dramatic. But it's actually a flexible tool that, if it is wisely implemented, can help innovation rather than blocking it. And this is why I use this title immediately after the publication of the EDPB opinion on LLMs and personal data. I use this title for a LinkedIn post. And now I'm about to transform it to a whole article with a critical assessment. And I think that it's very timely because this EDPB opinion published last December arrived amid growing EU policy momentum to reduce regulatory burdens and foster AI innovation. And I know that the opinion has been criticized by many of my good colleagues, including on LinkedIn, for a potential overreach or lack of clarity or being useless or a lot of things. I am trying to offer, both in my LinkedIn post and in my extensive paper, a more balanced perspective, a kind of, let's say, positive reading of the opinion, while acknowledging, of course, the undercurrents of uncertainty that it creates without doubt. So I inquire whether the EDPB stance is an opportunity to reconcile data protection with responsible AI innovation, or merely as some people claimed, another barrier, raising compliance costs and sowing confusion. And in doing so, I highlight both the strengths of the opinion, the good, also the most negative issues, the bad, but also the uncertainties, the ugly. And this is why I use this Clint Eastwood terminology.
Okay, so let's start with Clint Eastwood then. Let's start with the good, right? Who's the good? What's the good part, please, in the opinion?
Well, I think there is plenty of good in the opinion, or probably it's wishful thinking, but this is what I think. And one of the first things that I notice is that the EDPB makes clear that GDPR isn't designed to halt innovation. In fact, they explicitly say that the GDPR is an innovation enabling framework, I quote. And I do hope that this is not just an empty talk. This is significant, especially today, because there is currently this strong momentum in Europe to streamline regulations, reduce red tape, and boost competitiveness. So the EDPB explicitly acknowledges that AI provides major opportunities for society. They clarify that GDPR can facilitate rather than obstruct innovation, provided developers, of course, demonstrate accountability, use robust safeguards, provide transparency for data subjects, and enable data subjects to exercise their rights. Basically, they're signaling that GDPR should be a toolkit rather than a barrier. And if interpreted wisely, GDPR doesn't just protect personal data, it generates trust, I believe. And trust is an incredible market advantage, especially in a sensitive area like AI. Probably during the continuing of our discussion, I will be able to give an example with what happened with Deepseek. So when you're a company or an institution or a simple private user like you and me, and you need for your work, for your business, or even for personal queries that can be sensitive to interact with the generative AI model, what are you going to choose? An AI system that has done a lot of efforts to protect the requirements of the GDPR and for which you have the feeling that it protects your data, or a system for which we have no such guarantee. I think that regulation creates trust, and companies, institutions, and even individuals will naturally prefer AI systems that protect their data over those that might misuse it. And that's what I would call the trust dividend, and GDPR helps create that. So in my paper, I tried to argue that the EDPB opinion of last December on AI models offers an interpretation of the GDPR, and especially on the critical issue of legitimate interest, that is flexible enough to permit the development and deployment of AI models in Europe and their use without compromising the essential safeguards of data protection. Some critics have questioned whether the EDPB opinion hinders innovation. One good colleague even went as far as saying, I remember in a blog post, that the opinion outlaws LLMs. However, if, and again, it's an if, and for all the ifs in the world, we can put Paris in a bottle, as you know. If read in light of the GDPR roles as a legal framework that encourages responsible innovation, I repeat again, the opinion can be viewed, I believe, as sufficiently protective while leaving significant leeway for generative AI developers to rely on legitimate interest as a legal basis for training LLMs with data sets that include personal data. So, for instance, let me give an example. Part 3.3 of the opinion proposes multiple practical measures, such as limiting the collection of personal data, offering transparent information to data subjects, putting effective safeguards in place to ensure individuals' interests and rights are protected. And all these measures can be adapted and scaled depending on the model scope and associated risk. For instance, when the EDPB says certain sources must be excluded from data collection, certain websites that are particularly intrusive due to the sensitivity of their subject matter could not be collected. Exclude also collection from websites or sections of websites which clearly object to web scrapping. I think that all these are very good practices. This is why I talk about a toolkit. And it's both flexible and capable of giving meaningful effect, a meaningful effect, to data protection principles. So I think this is workable and protective as well. And this balance stance helps AI developers navigate the GDPR rather than feeling that somehow that they are paralyzed by it. So, and another, just if we have the time, another significant positive aspect, for instance, that I discussed in my paper is the EDPB's careful separation of data protection from intellectual property issues. And I make a contrast here with the position of the UK ICO in its own guidance published just a few days before the EDPB, which suggested that generative AI developers might struggle, I use the ICO's expression, to justify web scrapping using publicly accessibly online data as necessary under the GDPR's legitimate interest test. And the ICO even suggested developers should instead seek licensing agreements with content publishers. That this is a solution. And that advice, I think, mixes IP rights directly into the GDPR framework, implying that licensing is the primary, if only the sole method of achieving GDPR compliance. And I think that this could be problematic.
Good point. I think the EDPB also opened the door to that, to conflating IP with personal data, because they're talking about robots.txt and just opening the door to the whole data scraping debate, which has been a big debate, big part of AI training and so on. So, and also I understand the struggles of the ICO with scraping the Experian case, which they lost, for the use of legitimate interest and all these things that happened. So, but from your point of view, what's the problem of combining IP, intellectual property with data protection?
I think that the two are very important. There are two different pieces of the generative AI puzzle, extremely important. But I think that they are different. Licensing agreements are about copyrights, permissions, commercial interests. GDPR is about personal data, individual privacy, transparency, and data subject rights. Conflating the two, I think, muddies the water significantly. For example, the Garante, the Italian Data Protection Authority, as you know, question just 2 months before the ICO opinion, or a few weeks, question whether publisher licensed datasets could generally satisfy GDPR's strict requirements, including the strict test about legitimate interest. So you understand that developers following one regulator's advice might find themselves in trouble elsewhere. And fortunately, I think that the EDPB didn't take this problematic route, with one exception. You are right, there is one exception that I discuss extensively in my paper, in the ugly section this time, but we will not have enough time here to enter into this. But I think that with only one exception, the EDPB clearly separates these frameworks, keeping the GDPR scope purely on privacy issues.
Yeah, very good. Yeah. So you mentioned this constructive interaction between the GDPR and the EU AI Act. Some people say that these two may clash at times. And one thing that I wonder is whether, since the AI Act has not worked so much to make it very, very, or maybe it was impossible, right, to make it really clear, to really sync it with the GDPR, although probably the easiest thing is to just simply delegate to it. Could we have done this thing the other way around? And now that we are polishing up the GDPR, automated decision-making, LLMs with potentially personal data, and could we have made the guidelines speak the language of the AI Act?
Yes, thanks for this question. I think it's a very important question that I also discuss extensively in my paper, and which has already created a lot of debates. And what I see in the EDPB opinion on generative AI models is that I see a lot of wisdom on this, personally. I think that the EDPB has done a good job here. Rather than creating confusion between the two, the EDPB has taken a very deliberate step to ensure both regulations speak the same language and to prevent duplication and to provide some kind of clarity for AI developers. Let me give you an example. After the EDPB opinion, my good colleague here in France, Juliette Sénéchal, published an article on the EDPB opinion in French and raised an interesting critique. She suggested that the EDPB missed an opportunity to incorporate the AI Act's systemic risk or even high risk requirements and categories directly into the GDPR legitimate interest balancing test. And while I understand this perspective, I respectfully disagree, as explained in my paper. Why this? Why disagree? I think that the AI Act addresses broad systemic risks to safety, human rights, and public welfare, risks which can be entirely unrelated or very distant from privacy concerns, like, for instance, the risk of cybersecurity threats or threats to critical infrastructure or manipulation campaigns. In contrast, the GDPR focuses specifically on privacy risk and individual data protection. If the EDPB had linked systemic risk classifications of generative AI models directly to GDPR compliance criteria, it would blur these lines significantly because developers might mistakenly conclude that being categorized as systemic or even high risk under the AI Act automatically means failing the GDPR test of compliance and legitimate interest test. I think that this would not be helpful. And each framework serves as a distinct, complementary purpose. Each framework has its own safeguards. And of course, we introduce risk categories in order to mitigate them with the appropriate safeguards. And I think that by clearly separating the objectives of the AI Act and the GDPR and the safeguards, the EDPB prevents both unnecessary overlap and confusions. And it avoids giving this feeling to developers of duplication, contradictory obligation onto a very harsh regulatory environment.
Thank you. Very good. So let's talk about the bad. And so you mentioned a high standard for anonymity, and this connects with a few interviews we've had before.
Yeah, I think I found this really bad. The EDPB dedicated so many pages of its opinion on this specific issue by setting such a high bar for anonymity that hardly, I think, any known large AI model can ever reach it. I think it's like asking AI to vanish data, like David Copperfield makes the Statue of Liberty disappear. You know, it's impressive, but not really feasible for AI developers. The EDPB sets an exceptionally high threshold for what counts, according to it, as anonymous. So they transpose their criteria for anonymous data, the strict, very restrictive criteria for anonymous data, to models, which is already a semantic slippery slope, if you want. But their opinion basically says that an AI model isn't anonymous if it can respond to the following question by user: who is Emmanuel Macron? Without real-time web-based retrieval. So and I confirmed this during a recent Future of Privacy Forum call with members of the EDPB. They said, yes, indeed. So there is none of the well-known general AI models, ChatGPT, Gemini, Lemmy, Claude, Mistral, whatever you want, Grok, take them all, that would pass the anonymity test. And I wonder also, do we want to be the only ones in Europe where models cannot answer the question, who is Emmanuel Macron? This is what we expect as a protection. And do we want to have generative AI models that can tell us nothing about people in general, because it's not about just names, it's also learning about people and what we do. And also separately, and more technically speaking, the EDPB also said that an AI model isn't anonymous if it is possible, even theoretically, to extract personal data. And it suggests that then even there is just a mere theoretical chance of re-identifying data, the model stays under the GDPR scope. And I think that this, as has already been mentioned also by Peter Craddock and also others, this contradicts the European Court of Justice approach and standard, where anonymity should depend only, as I said, on lawful and reasonably available means for re-identification. This was the approach precisely of the Hamburg and the Danish DPA. The Hamburg DPA, as you said, you have already had a podcast on it, on this very interesting paper, and we might come back later. But basically, I think that this whole part of the DPB opinion was written solely in order to refute the reasonable and practical approach of the Hamburg DPA.
Okay. So let's go for the ugly. There's a lot to unpack here.
Yeah, yes.
So let's go.
Forget the ugly.
And so you talk about a case-by-case conundrum. Why is that problematic?
Yes, a lot of colleagues said this, that the EDPB repeats always the phrase to be assessed on a case-by-case approach. And this creates a lot of ambiguity. Critics rightly point out that this leaves a lot of room for inconsistent interpretation between DPAs in Europe, and that this translates to uncertainty, and uncertainty creates anxiety for business. So it's like telling business, you may or may not have stepped on a legal landmine. Let's wait and see. Nobody likes that. This is something which is clearly ugly in this opinion.
Yeah, there's also a positive side to that, right?
Yes, there is a positive side. This is what, because I always, even for the ugly things, I try to find positive outcomes in my paper. And I think that somehow it's a strength in disguise, because this flexibility left by the case-by-case approach lets innovators justify their own smart ways of protecting privacy. This encourages creativity, I believe, provided, of course, that regulators use, once again, for all the ifs in the universe, we can put Paris in a bottle, if regulators use this flexibility responsibly. Flexibility must be paired with responsible enforcement. And I think that regulators should encourage innovative privacy approaches in relation with generative AI models. So I think it might be good, this flexibility.
Thank you. So you talk about blind spots as well in the opinion. And so things that were ignored in the opinion that are important, like processing sensitive data. So why would they leave that out?
I think that this is a gap which has also been highlighted by a lot of colleagues. In reality, about especially sensitive data, when I read the opinion for the first time, my first reaction was, did someone in the EDPB Secretariat accidentally deleted the question on sensitive data from the DPC's request? And joking aside, I think that this omission matters because these topics are very, very important for AI developers. I guess that this was also one of the main points you have discussed with Locke Morel and others. And as a matter of fact, many AI data sets which are used to train these models unintentionally more often contain sensitive information, but sometimes also the developers say it's important to have this information because generative AI models must know things about things like, I don't know, health, religion, political opinions, sexual orientation. We cannot just deprive our models from all this. So in a way, the EDPB gave developers a complicated recipe for making generative AI GDPR compliance soup, if you want, but accidentally left out the most important ingredients. I don't know, water and salt, for instance. And now developers are wondering, should we cook anyway or just wait to have the whole recipe? How are we going to do?
Yeah, and again, you stay optimistic, and you always look at the bright side for this, right?
Exactly.
So
look at the bright side of life, because I think that this lack of clarity might also be a silver lining. I mean, I prefer it to an extremely overly restrictive approach on this issue, which would have eventually prematurely locked down some approaches. And it might be better to think more carefully. And I think that basically the EDPB is saying here, we haven't answered this yet. We are leaving you some room to innovate, to do protective things, which will not hinder innovation, but just don't go too wild while we are figuring this out. I think that this is how I read this omission, personally.
Okay, okay. Then there's another tricky part, right, in the opinion, and that's this approach to their approach to mitigating measures. And so you also mentioned that it creates a very rigid distinction between the basic measures required for, by again, for GDPR compliance and beyond that basic level of compliance. Why is that a problem?
I think that there is no Berlin Wall, as the DPB suggests, between compliance measures and extra safeguards. In reality, things are not black and white here. GDPR compliance is not binary, and there is a whole spectrum of approaches. You can do the bare minimum as a data controller, just ticking the GDPR boxes with the bare minimum, or you can proactively do a lot of things to protect privacy. And I think that the EDPB's position here implies that anything done simply to comply does not count as a mitigating measure to pass the balancing in the legitimate interest test. But I think that this doesn't work because practically every advanced privacy technique you could imagine, pseudonymization, differential privacy techniques, advanced transparency mechanism, everything can be classified as basic compliance. So the core issue for me here is that the EDPB's overly theoretical distinction risks overlooking genuine privacy-enhancing frameworks. The measures, the objective is to reduce risks, regardless of whether they are part of the compliance or extra steps. And if somebody takes these measures, very active measures to reduce risk, it should be positively influence this, I think, the balancing test. So in short, privacy isn't about just checking boxes, it's about actually reducing risk for people. And I think that the DPB adopted a very theoretical approach here. And it should instead, whatever the qualification of the measures, it would incentivize developers and deployers to reduce risks and recompensate them for that, for this.
Okay, so let's move to something slightly different. It illustrates all of these problems very well, right? The analysis you've been doing, or the case study, right, of Deepseek, which was a big hit. It did make a splash. So what went wrong, if anything did go wrong?
I think precisely in relation with all the things that we have discussed, Sergio, that the Deepseek's launch was a kind of, inviting the whole neighbor to a barbecue party without checking if you're actually allowed to light the grill. And Deepseek did exactly this. It rapidly became popular due to its powerful and efficient AI model, which is good. But its launch in Europe and elsewhere overlooked critical GDPR compliance requirements. They didn't sufficiently consider privacy policies at the beginning. They didn't consider data storage transparency, clear communication about data handling, about storing data in China, and several other issues. And as a result, regulators around the globe, starting with the Garante only 2 days later, quickly jumped into action from outright suspensions to extensive investigations. And not only in Europe, also in several other, you will see we will create a table with my colleague with all the regulatory actions and links all over the world. So basically, Deepseek went viral, and so did the regulatory backlash about Deepseek. And this shows how important probably regulation is.
You know what? I think I could even push back against the whole thing because it is true that there was all of these regulatory, there were all these issues, but maybe they wouldn't have made a splash if they had taken the time. I know I'm going to play devil's advocate for a minute, thinking that they could have just released the model and there was no risk. You could deploy your model in your own server, right? But they went it farther because they wanted everyone to taste it. And they deployed their own website with their own, right, hosting the model themselves. And that became the whole problem because it's so easy to keep it for yourself. But they were eager. They wanted to be first. If they had taken the time to understand the law, from, again, it's still a small company.
They could, I think they could have asked Deepseek basically, even if they're not able to hire a European or global data protection lawyer who could advise them very, very quickly on this, I think, because we have precedents. This is what happened with OpenAI and ChatGPT
Yeah,
in
of course.
November 2022, and they already have one fine and 14 other complaints and investigations pending. So you see the thing, I think that precisely, no, you take the time. You don't skip the data protection and privacy part. It's not possible. Trust is absolute key. It's the foundation of innovation. If people don't trust your AI model, no matter how revolutionary your tech is, it won't gain sustainable traction. I think that DeepSeek issues illustrate precisely why responsible innovation matters. Skipping regulatory steps in the name of releasing the model 1 or 2 days earlier, when it's extremely easy to deal with this. I mean, any lawyer giving them advice could have dealt with this very quickly, unless if there are deep technical problems behind. But creating a specific regulatory policy applicable to Europe and taking into consideration the GDPR requirements and permitting to exercise data subject rights, as they did finally a few days later. But what is funny is that they released a model and the guarantee asked for information, and they responded to guarantee that the GDPR is not applicable to them. They don't even, I mean, this is what I said to my students. Why they didn't ask Deepseek? I'm sure Deepseek knew the answer about Article 3 and why it's applicable. So if you miss all these regulatory steps and you don't bother at all, eventually you will hit a wall of regulatory scrutiny. And this is something very, so with my colleague Pankaj Raj at the AI regulation chair in Grenoble, we created a table with all the links. And basically the lesson that we have from this is simple. You can't build lasting innovation without building trust first. Otherwise, even your most groundbreaking AI might just break down in front of the entire world.
Yeah, thank you. Of course, I agree. I mean, I'm helping startups do that, but I understand their point of view. Time is of the essence. They're not making any money by doing this. The only advantage they got, the only thing they were going to win is be there a few hours earlier and just dealing with the whole, landscape for them. I understand how they think. That's the thing.
Is it
But you're
better
right.
for them? Is it better for them now? I mean, if you see the table we have created with my colleague, it's so many regulatory actions, so many suspensions, both about online use. Of course, you're right, you can download it, but also there were suspensions of downloads or even prohibitions of downloads in many cases because you might fear there might be backdoors or whatever. So I think that you're not going to convince me. I think it would have been perfectly possible to deal at least with the privacy requirements. And if they don't have a lawyer in their team and they want to break things and move quickly, at least they ask Deepseek or another model who can provide some kind of legal advice here.
Yeah, maybe you read a Donald Trump book, and followed his advice that every publicity is good publicity, even
Yes,
a
no
fine,
problem.
because now everyone knows the model. So all of these problems, right, lead very nicely into a big issue if we talk about trust, which is hallucinations. And that's a big one, because one thing is having all your paperwork in order. Another one is that people start using the platform and then they do not trust it, because whenever you ask something that is in our domain, then you realize it's just, again, it's full of BS, as they say. So could you explain what these are? Why are they important from your point of view in the context of the GDPR?
Yes. To explain, first of all, I think that AI hallucinations, for somebody who does not know, is basically the equivalent of those wild stories your eccentric uncle tells during family dinners. They sound convincing, about fishing big fishes and things like that. They could even be plausible, but often they're completely made up. And in AI terms, it means that the generative AI model confidently generates information that might simply be false or nonsensical. So these hallucinations matter from the GDPR point of view. First of all, because it can give wrong information about specific people, that you're a criminal or that you have done something wrong, and this can have very important reputational consequences. But beyond this, this can also this could also violate the GDPR principle of accuracy, and so directly challenge the GDPR. And this was the object of a long paper published a few months ago. And I think that the issue here is how to deal with this problem.
So you do mention in your paper that some regulators like the Hamburg DPA suggest shifting attention from the models, away from the models, and focusing on the outputs, right? So can you elaborate on that,
Yes,
please?
I think that the Hamburg DPA that you have already mentioned, your podcast with Marcus, um, and with Locke Morel. I think that they provide a very interesting and insightful practical guidance. Essentially, they argue, as you know, that the inside the LLMs, which is part the core, but just part of an AI systems, there are no personal data like traditional databases, and instead they explain that the AI systems generate outputs probabilistically based on patterns. And I think that this distinction is crucial because it means that the traditional, let's say, principle of accuracy in the GDPR, which applied to datasets, cannot directly fit here. So the Hamburg DPA suggests that regulators and developers should focus on other parts of the AI system, and especially concerning hallucination on outputs, because that's where the GDPR clearly applies. And rather than chasing theoretical ghosts within the AI's neural nets, it might be more effective to manage the concrete risks presented by what actually comes out from these systems. The industry has adopted a lot of measures to address these. For instance, they have introduced sophisticated filters to flag and block obviously inaccurate or potentially harmful outputs. They have focused on transparency and user empowerment. Users are clearly warned that generative AI outputs might not be reliable, and this encourages also healthy skepticism. And they have introduced also advanced methods like dynamic fast-checking, grounding responses in verified external sources. And let's not forget that all the new models that we see now and it's going very fast, include internal reasoning capabilities. And this, of course, can help minimize hallucinations. So ultimately, companies are striving to manage GDPR risks without stifling innovation, aiming for an AI landscape that's not just creative, but also accountable and trustworthy. And this is why precisely I think that we should avoid overly restrictive interpretations in such a field, especially which is so rapidly evolving. We must hold companies accountable, but we must also provide the necessary flexibility for innovation.
Very good. And you mentioned reasoning models, and I've heard that could be the answer. How for things that could have a lot of data or even sensitive
Exactly.
data, then you just simply use reasoning models that will check everything, go slowly, take the time, hallucinate much less. Is that the answer as well to cover the the accuracy principle and to cover these rights related to it. So people being able to, correct their information, even, the right to just, erase their data. That's very tricky. How are companies dealing with these rights?
Yes, I think, as I said, they adopted all these methods. All the companies, I have, when I was working on my paper, I tried to consult the policies of and the evolution and the techniques used. I read a lot of blogs. I spoke with a lot of previous engineers, and they are trying to introduce a lot of methods. And I think, I do hope, I'm not a computer scientist, but I think that from a legal point of view, there are a lot of measures that have been taken. From a practical and technical point of view, a lot of solutions that are implemented. And as you said, the combination of these new models, which are capable to reason, capable to introduce nuance also, and say, I don't know, or my response might be wrong, and combined with all the systems that we have now of deep research and retrieval from the internet of information, all this could, of course, not exclude, but at least reduce the risk of hallucination.
Thank you. Okay, so in summary, you seem to be making a strong case for the value of regulation as a good thing, right? But it must be practical, balanced, and clear. Is that it?
Exactly. I think that regulation can protect us and simultaneously encourage responsible innovation if, once again, it is wisely implemented. The GDPR applied correctly should not hinder Europe's innovation capacity that we need desperately. Instead, it can foster, I think, a marketplace where privacy respectful AI systems can flourish. Regulation should guide innovation, not kill it outright. And after all, as I always say, the GDPR is not a suicide pact.
Very good. Any last thoughts?
Well, I think once again, regulation must be wise, never wild, and with a sensible interpretation and enforcement, Europe can excel at AI innovation while protecting its values, including, of course, data protection and protection of privacy.
Thank you, Theodore. Thank you. Very useful. Thanks again.
Thank you so much for having me.
Okay, that's all for today. Follow us on Blue Sky and in the Masters of Privacy Altogether profile, you will find the starter pack, which includes the feeds of all of our past guests. There is also a Masters of Privacy LinkedIn channel, which I invite you to follow, where you will find links to our transcripts, cheat sheets, and other surprises every now and then. Our main website is mastersofprivacy.com. Thank you for listening.